clarify the recent opinion basically as to the relevance of the issue of Scientology, or in the alternative, we've requested a clarification as to whether the respondent will be able to produce evidence on the issue of Scientology and its effect on the custody of the children. Basically, we are pursuant to KRS 403270. The court is to examine all relevant factors in a child custody case and determine the best interests of the children. This court basically...
Summers, let me do the page 5. Oh, you make it.
Okay. This court has really heard very little about Scientology and determining the part about theories and principles of Scientology. This issue, and taken Mrs. Padgett's deposition, the majority of the questions were not responded to. They were denied because of harassment in the interrogatories and the production of documents. We also have had a problem getting a lot of these things. The court, in its opinion, stated as supporting documentation.
Well, it's great. There were 3 different files, and one was in there, but I thought it was left in the box. Okay, go ahead.
Okay. Used in your supporting documentation, the petitioner's deposition was used to support that Scientology should not be an issue. There was major parts of the deposition that were cited, and the majority of these questions were not answered as they were stated. They were harassment. But I think the important thing that came out of all of these in the deposition, there was on page 4 of the order, I think there's one very important question that was asked and came out of all of these, and that question was, the critical question is the children's involvement in Scientology. And it was admitted the children are going to the center. They are involved. Throughout in our documentation, in our memorandum of law and our supplemental memorandum and all the documentation that we have cited and stated, we have said we are not trying to restrict her beliefs, her policies, her theories, her religions, whatever. We are concerned with the impact on the children, and we are concerned with the children's involvement. That is what we are requesting. We are not trying to restrict her beliefs, her ideals, or anything other than as custodial parent of these children. Also, in your order, you cited that the respondent had not persuaded you that Scientology is a cult. We're not really asking you to take his opinion. We have cited...
I don't believe I ever stated that in there.
Well, you said basically on page 6 that he had stated that you did not, he had not persuaded you that this was a cult.
I don't know that I can determine what a cult is.
Right. Well, that's what I'm saying. Whether this be a cult...
I mean, there's a big difference
right.
between not saying that it's
sure.
not a cult or...
Well, what I'm trying to say, Your Honors, we're not asking you to believe his opinion. We're saying whether this is a cult, this is a religion, this is an organization. We are asking that this issue be heard for the impact on the children. We are not requesting that her beliefs be restricted.
You have a copy.
Yes. Her beliefs be restricted. We are only asking that the children's involvement be heard before the court, that the impact, whatever as custodial parent, if there's any impact, that be heard by this court. I cited the University of Louisville as a law review article that talked about, and from that, the 1990-91 published case, volume 29, stated Scientology was the second largest cult in 1985. It cited other cults, the Moonies, the People's Temple, the Church of Armandetta, but it gets down to the bottom line. Whether this is a cult, a religion, an organization, it's what impact is here on the children, what involvement the children have. We are not requesting that her First Amendment and 14th Amendment rights be denied. We are not denying her free exercise of religion. We are just saying this issue is crucial to be heard for the children. Not what Mrs. Padgett wants, not what Mr. Padgett wants, but the important part of the children. And you did state in your order that there has been no prima facie case of harm shown. You cited some examples of snake handling, being deprived of medical attention, and other such factors. This organization deals in mind control. They require total and absolute commitment by the people that are involved in their organization. Mind control can be as damaging to these children as snake handling if they're involved in this. And this is why we'd like to bring in, we're not asking that you just hear Mr. Padgett, we're saying there are people, there are experts out there who can...
Reference to the John Locke quote, for it believes that all religions are cultic or sectarian in nature. But the court is making no finding as to what exactly the Church of Scientology is or is not. And courts may be called upon to, in a sense, grapple with that issue and deal with the definition of religion. But I don't think that it has to do that in this case, and I have not seen any evidence that the children have been affected by acts of this religion. Now, Mr. Alberton, you may respond to what Ms.
This is nothing
You
more.
get to respond.
This is just a rehashing of the memorandum that we have previously filed and the oral arguments that we have previously presented to you on this very issue. I believe that your order is very clear, concise, and authoritative on the very essence of how religion is interwoven into any divorce proceeding or now custody proceeding. And that is that they have just simply not shown that this religion is harmful in any shape, form, or fashion, but that's just that they want to put a general attack on the Church of Scientology. As I stated in my brief, it would be nothing more than a Jewish person versus a Catholic parent, that sort of thing. And they just haven't come close to chinning the bar to go forward with any type of proof as for the attack on Scientology.
Ms. Padgett, do you
Okay.
wish?
Your Honor, basically,
Ms.
we have...
Lewis,
I'm sorry, that's okay. We haven't shown a physical, like snake handling or being deprived of but we have shown there is a harm here. Basically, their theories and principles deal with mind control. What we are asking is in total commitment that, number one, the custodial parent in itself has to have total commitment to the organization. Any custodial parent who has total commitment to something that would help to control their life or control their life has an impact on these children. These children will be impacted by that. They're very involved in this. These children are attending seminars presently that deal with mind control. That's been an issue. I'm not saying that I can tell you about this, but there is experts who can tell you about this. Dr. Nichols did not deal with this issue. She talked a great deal about Scientology, but she did not give an opinion as to harm to these children on Scientology, and I think she did not because she is not an expert on this. And I think that's why she did not address that issue, because in conversations that dealt with Dr. Nichols, it was basically determined there would be experts who would come in and talk about this. And I... Go ahead.
Your Honor, I think we could probably, and I haven't been here for all these arguments, and as Mr. Halliburton said, this issue has been addressed. I think to cut to the shape of the issue is basically your ruling, Your Honor. Is it foreclosing the issue of Mrs. Padgett's beliefs, whether they were Scientology, Jewish, snake handling, or whatever, foreclosing that at the final hearing on the determination of what's in the best interest of the children as to custody? Because I believe the statute says all relevant factors. And I think if, we could, like I said, be here till the cows come home to argue that issue. And that's really, I think, cuts to the quick with what is this court's ruling on the issue as it is to relevant, as it applies to the children.
I believe your ruling is very clear that by citing the questions that we refuse to delve into by way of answer that those questions are inappropriate in this case, which they are. Again, Dr. Nichols, this is gone through a court-appointed psychologist, and she found that there is no type of harm whatsoever to the children, be it the conclusions that Ms. Lewis says about mind control
Your Honor,
or otherwise.
on page 4, I do wish to point out to you, the one thing out of the deposition that I was attempting to get at was not Mrs. Padgett's beliefs and trying to restrict her beliefs. The one thing I was trying to get at in that whole thing was the involvement in the children. And she admitted the children are attending. She admitted it to Dr. Nichols. They are attending the centers. We don't know what they're doing there. I haven't been told. I haven't been able to find out. I know what some of the theories and principles are, and that's what I'm basically saying. Without this information coming to the court, it is incomplete to have this hearing of custody on the children.
Well, I went through the deposition and looked at all questions that you asked, Ms. Lewis, that related to Scientology, and I could not determine any of those questions really went to the merits of the welfare of the children. For instance, on page 4 that you recited to, you asked the question, am I correct in stating that there is no God in Scientology, that is actually worshipped in Scientology? And what relevance whatsoever would that have to do with the children?
Well, basically, Your Honor, what I'm trying to say is, what reference would that have to do with the children?
Well, what's the importance of that? Why is that question relevant to any inquiry that this court may make?
Because religion, basically, Mrs. Padgett has basically said this is a religion. Religion, by definition, in the dictionary, usually talks about devotion to some being, to some God or being. And what I was trying to determine is the beliefs or the principles of this religion, that the children are attending. They are involved in this. They are attending this. One of the children at this even say they are a Scientologist. And I think it's important to know about this and determine about this. And through her, she's the custodial parent who has taken these children to these centers, and I thought it important to try to obtain information from her. There's psychological effects and things that can affect these children. Other than, I mean, you cited
But you haven't
specific
presented
physical.
you haven't presented any such evidence.
No, Your Honor, what I tried to show is the relevance of this, and I think through the children attending this, they attend this, they go with their mother, they attend this organization, one of them says they are a Scientologist. I think that makes it relevant to the court.
The court overrules the motion to reconsider, and I believe that the order is sufficiently explanatory. The kinds of questions asked are not relevant. If you have evidence of harm to the children, then you can bring that forward. And if at any point in the future, if that comes up, I mean, even post-decree, then I think that that's relevant, that goes to harm being visited upon these children, then that becomes relevant and subject to modification. But at this point, the court overrules the motion to reconsider.
Your Honor, and that harm, if we can present proof of that harm to the children, would be admissible then at the hearing, the final hearing, on the ultimate issue of the custody.
Yes, I mean, if you present evidence of harm to the children, and I don't know, Mr. Halliburton's shaking his head as if he agrees with that.
I do. I've said that all along. If they can show the harm, but they just haven't chinned the bar to even show that there's a hint of harm to these children.
And I guess it's just the timing of when to show the harm, and if it is...
Well, I mean, any harm, I mean, that's happened or is happening now. Now, I don't know how you can look to the future and know.
Sure. But, I mean, what I'm saying is the harm at the time of the hearing would not, if there is indeed harm, proof of harm, at the time of the hearing would be, once again, for Mr. Halliburton to be available to cross or the witness to be available to have his cross-examination would be appropriate to bring at the final hearing. And I think Mr. Halliburton shook his head to agree with that.
Okay.
I think Mr. Hinton's here to give us court date.
Just sign your honor.
Yes, yes. And you also want some dates for
We want dates for a trial date, yes.
he called in this morning. But, I don't think he's going to be here. He wanted various dates.
Okay.
Okay.
Give you as a possibility May the 5th and 6th.
That would be fine with me, Your Honor.
I've got a problem with the 6th.
The 6th is the
Do you think it's
problem.
going to be a 2-day hearing?
I think it'll be at least a day and a half.
Yeah, I mean,
It won't from my delivery.
Another possibility, May the 19th and 20th.
That's okay.
that's fine. Yeah.
That's fine, Your Honor.
I have a trial starting the 17th that would go in 4 days. Federal.
Why don't we go back to May 5th and 6th, Your Honor? I can work around my schedule.
I think
If
I
that's
can,
okay.
I
Is that
can
okay with
change the thing on the 6th, I think.
So that's fine with me.
Yeah.
Commissioner still leads a busy life, too.
Yeah, let's,
Was that a date
why
he
don't
had
you go back
selected?
and have Carolyn call and see if that date's acceptable to him.
If you don't mind, so we can kind of
Okay.
foreclose this.
Okay.
I
Is it-
think the dates of May 5th and 6th were fine. Mr. Halliburton? There was one other short thing that I needed to take up with the court this morning. We have previously in the past, Mr. Halliburton had made a motion that if you remember the leaflets that Mr. Padgett was passing out,
Okay.
remember that? And we had also requested that he has received several letters, telephone calls and various things at his hotel from different various places where Scientology is, plus things that have happened at his home. He recently has received, well, his hotel did, he didn't receive it, a letter also from Royal Oak, Michigan, which is one of the centers of Scientology. And what we are asking is just, I know we can't directly say she's done this, but you also asked him to get a hold of the people that were sending out the flyers and to stop them. We are asking that indirectly, if she knows anyone that is doing this, because it's posing a very bad problem for him and his employment, to ask them to please stop this.
She does not know. I've asked her. She has assured me that it has not been requested. She has inquired about it and has been assured that it's not even happening. Whatever it is that he's alleging that they are doing, is just unbeknownst. The thing about the flyers, now, if you remember that, he had direct involvement with that, and he was passing them out to people. He has violated that order since then. We even have a videotape of him violating that very order regarding the flyers. But that's not what we're here about. And as far as this harassing, whatever it is, nobody should be harassed, and nobody is being harassed by our side.
Your Honor, I personally received a letter myself, as I've told you. I'm just saying, indirectly you had ordered him, if there was anyone that was passing any flyers or anything out, you ordered him indirectly to stop this. And what I'm asking is basically to just give us something to say that we want this stopped. If she knows of it, I know he says she doesn't, but if she knows of anyone that would do this or continue to do this, because it's creating a real employment problem.
That's quite an assumption that it is happening, though. I have not seen that this is actually happening to Mr. Padgett. I don't know. We have seen that he is controlling various mailings, but as for this, we are not doing any harassment, communication, or otherwise. period. And I have, again, asked Laura about it, and she has assured me that, you know, it's been some while ago that she checked into it, just to see it.
In the order that comes out of today hearing, let's put language in there that each litigant and all acting in concert with either the petitioner or respondent are ordered to refrain from any harassing contact with one another.
That's in the prior
Yeah,
order.
because after that, the prior order, Ms. Lewis, somebody sent me something, which it was from, it had a whole bunch of people signed their name to it, and it said something about the court had previously ordered parties do such and such, and that because the court didn't do something, and I can't recall the specific language, but that, you know, the court's not concerned about human rights, and, you know, the court is. The court might have a different perspective of rights than the litigants, but nonetheless, yeah, I mean, it's a hard thing to pin down. I mean, Mr. Halbert's made reference to video with you. I hadn't heard anything about that, but
I haven't even first I've heard, but I think that order, I think it should be in there. Thank you.
okay, Mr. Halberton, why don't you go ahead and draft the order for today's.
Commissioner Hinton wanted a mission statement, which is basically a pretrial order type of thing, of all issues, proposal of property division, marshaling of debts, and the listing of witnesses and the issues that are to be presented to him. So I told him, of course, and Ed was there, and we told him that we would furnish that. He wants to, before the hearing on May 5th.
7 days.
He wanted to set 1 week lead time, so I will back
put
it
that
up
in the order.
to by Thursday,
April 28th.
April the 28th. We will do that.
Thank you all.